Going on the record, State of Wisconsin versus DeQuella Collins, case 25 CF 1634, appearances.
Matthew Tarbinson appears for the state. Good afternoon, Your Honor.
Attorney Abigail Ruckdash on behalf of Ms. DeQuella Collins. She appears in person. Good afternoon.
Cell phones, please.
All right, she's in person. Good afternoon, Ms. Collins. We are here for a sentencing of following guilty pleas to 2 counts. 1, neglecting a child where the consequence is bodily harm as a party to a crime. That's a Class H felony. And count 2, straw purchase of a firearm, a Class G felony. I believe we're ready to go. Don't believe. I don't have any pretrial filings that speaks to anything, character letters or victim impact statements or anything like that. Is there anything I should have from the state's perspective?
No.
From the defense?
No.
All right, then I'll hear from the state first.
Your Honor, the state's recommending that the court sentence Ms. Collins to a term in the Wisconsin State Prison System of 3 years initial confinement, 4 years of extended supervision. On April 1st of 2025, Ms. Collins' 6-year-old son, DeQuell, accessed a firearm. He possessed that firearm and used that firearm, ultimately resulting in a gunshot wound to his head. Just after 9:30 in the evening, Ms. Collins' mother, Alicia Collins, discovered DeQuell with a gunshot wound to the head. She immediately phoned 911. Emergency responders arrived on scene within minutes and attempted life-saving measures on DeQuell's body. Those life-saving measures proved unsuccessful and DeQuell was pronounced deceased on scene. DeQuell was just 3 days shy of his 7th birthday when he died. The death of DeQuell was completely and wholly preventable. We have a problem in Milwaukee County with firearms. We have a problem in Milwaukee County with felons possessing firearms. We have a problem in Milwaukee County with individuals like Ms. Collins purchasing firearms and giving those firearms or allowing felons to use those firearms. An argument can be made that Ms. Collins suffered the greatest penalty one possibly could for her actions already, because by providing her brother a firearm, by allowing her brother to access her own firearm, she has lost the life of her son. And there probably is no greater penalty for Ms. Collins for that. But when one examines Ms. Collins' text messages in her phone in the month leading up to what happened, it demonstrates that Ms. Collins, with her brother, was acting in concert to get him a gun, to allow him to possess a gun, to allow him to make arrangements to sell her firearm to others in the community. All in an attempt to avoid the consequences. Quintel Collins was a convicted felon. He had just been released on extended supervision for his felony fleeing offense approximately a month or so before this took place. Ms. Collins knew her brother was a convicted felon. She knew he was not to possess a firearm. And she facilitated him getting a gun. She actually asked him to assist her in purchasing ammunition for her own firearm. The two would communicate fairly regularly about firearms through text messages, and it was during the late morning hours, just after 11 o'clock in the morning on April 1st of 2025, when Quintel sent a video on Instagram where he was rapping, holding Ms. Collins' firearm and his firearm. Haunting in that video are the feet and the legs of DeQuell that can be seen laying on the back of the couch. Also haunting in this case are the text messages that Ms. Collins sends to her brother in the weeks before, because she talks about how her son looks up to Quintel, how her son sees Quintel with this firearm that is, according to Ms. Collins, something that Quintel carried every single day with an extended magazine, a convicted felon, in her home, in front of her own child. And here we have a 6-year-old child doing what children do. Children are fantastic mimickers. They watch adults and they want to be like adults. DeQuell saw Quintel with a firearm. He wanted to be Quintel because this was glorified. This was cool. And it cost him his life. So in some respects, I understand that Ms. Collins has suffered a great penalty already through her own conduct. When she received that video on April 1st of 2025, she sent a text message back to Quintel telling him to put her gun up. Ms. Collins also, according to what she told law enforcement, called her mother and asked her mother to address the situation. She had a video demonstrating the danger right before her. She sent a text message to someone who's completely unreliable and sent a laughing emoji back to her, and then sends a message to her mother saying, "Can you also take care of this situation?" And then went about life as if it were normal. She didn't take any additional steps to protect her child, to get those guns away. Again, it seems to be just routine and acceptable conduct. I would think a parent who got a video of this with their child in the room would find it extraordinary, would find it alarming, would find it concerning, and will want to take actions to protect their child. To Ms. Collins' credit, after the death of her child, she's the one that provided the video of Quintel. She gave a full statement to law enforcement regarding what was taking place, at least with regards to Quintel possessing the firearm. Ms. Collins said that she purchased the firearm because she knew her brother was a convicted felon and knew that he brought a firearm into the house and that he brought drama. And therefore, she felt that she needed to possess this gun for protection. Those statements to law enforcement stand in contrast to the text messages that she exchanges with Quintel. It does not appear in her text messages that she's afraid of the people that are coming around as a result of her brother being released, having a gun, and engaging in the conduct that he did. It seems like she is embracing that conduct and wanting to be a part of that conduct. But Ms. Collins does deserve credit for, at least in some aspects, being cooperative with law enforcement, providing the video to law enforcement. With regards to Ms. Collins' character, she has one prior criminal conviction. It's a misdemeanor conviction. It's a retail theft from another county. It's from 2021. Beyond that, I see no other criminal conduct on the part of Ms. Collins. So before this, she had one conviction and for a relatively minor offense. Ms. Collins also deserves taking credit and accepting responsibility in this case by entering a plea, not taking the matter to trial. Certainly, she could have tried to take this case to trial and point the finger at her brother as the main person that was involved, though the text messages would have proved that to, from the state's estimation, be a futile attempt. With regards to protection of the public, there is a need for both specific deterrence and general deterrence in this case. The need for general deterrence in Milwaukee County is huge. should be consequences for individuals who provide firearms to convicted felons. And that's what Ms. Collins did. Our community at large needs to understand that there's going to be consequences, that there's going to be punishment if you try and avoid the laws by facilitating convicted felons getting guns. The state believes that there's also a need for specific deterrence with regards to Ms. Collins' punishment for her own actions in this particular case. Again, I understand that she has suffered a great loss as a result of her actions. I've taken that into account in two ways. First, in the reduction on the child neglect charge that she entered a plea to. She is not facing a homicide charge for which she was originally charged. And secondarily, I've taken it into account in the recommendation I've made before Your Honor with regards to the amount of time I'm recommending in prison. For all those reasons, the state is respectfully requesting that the court follow the state's recommendation of 7 years in the Wisconsin State Prison System, 3 years of initial confinement, followed by 4 years of extended supervision. I would leave the conditions of extended supervision up to the sound discretion of Your Honor. Thank you.
Thank you. Ms. Ruckdaschel?
Thank you, Your Honor. Every single person that's in your gallery right now is here to support Ms. Collins. I think that we're getting close to 24 people here. I think you can see that there's a lot of friends and family members that are here to support Ms. Collins, not only as she navigates this criminal case, but as she navigates the loss of her own son. The main person that's here that I know Ms. Collins relies on is her mother, Miss Alicia Collins. She's in the front row in the pink. I know Miss Alicia Collins wanted to address the court at one point, but is feeling a little bit too emotional to do so today, and I think the court can understand that.
Sure.
I know this court knows the galleon factors it must take into consideration here. Obviously, protection of the public. It's clear Ms. Collins is not a threat to the public. This isn't a shooting that happened and her son was caught in the crossfire or something like that. She wasn't shooting at anyone or being any type of reckless or doing any type of violent crime. She has been out on Justice Point since April of last year. As far as I can tell, there's been no issues with Ms. Collins being out on bond. She reports to Justice Point. She follows this court's order, this court's orders. As far as character of the defendant, Ms. Collins, at the time that this happened, was working a job. She was working at a group home. When she received that message from Mr. Quintel Collins, she was at that job. She did respond to Mr. Quintel Collins when she saw the video and said, you know, something along the lines of, like, don't do that in front of my son. And then he, in his immature ways, sends back a laughing face. Now, should Ms. Collins have followed up? Of course. Now, Ms. Collins did talk to her mother, Miss Alicia Collins, who is the owner of the house where Ms. Collins, her kids, and Quintel Collins were living. I don't know if that message ever made it to Quintel Collins or if it was too late or what happened with that. The issue that I have here, Your Honor, is sometimes we get caught in our own world here where we think people can leave their jobs whenever they want, run home, do that. Ms. Collins wasn't working a job where she could just leave whenever she wanted. She was working at a group home with elderly people, and if she would have just left, those elderly people would have been left alone. That's not something that her job allowed her to do. It's not like she was out in the club. It's not like she was out at a bar and just decided not to come home. She was working a job to provide for her kids. Ms. Collins was arrested. I believe that she has 16 or 17 days of credit from this incident. She did post bond, which was set at $10,000 and has been out on bond that entire time. When she originally was released from custody, she went back to that group home job, but was ultimately asked to leave that job given that the state licensing requirements for that group home. They told that group home they can't have someone who's charged with a felony working at that group home. I think that makes sense whether or not we agree with it. Ms. Collins then took it upon herself and has been working at Amazon since then. She works 4/12s, So she has works 4 on, 3 off. And on her off days is when she schedules and takes her children, her 2 remaining children, to therapy. One is 4, one is 2. Obviously, it's a little bit hard for children that little to sort of process what they've gone through and things of that nature. So I am really proud of Miss Collins for taking her kids to therapy, no matter how little they are. I believe they go to what's called shoreline therapy. They have offices in